Going back to the night of May 7th, the text message. We have the text message from Riley to Hayden beginning at approximately 11:01. It says, "Andy's in my room." A few minutes later, we have another text. That text indicates, "Shh, don't say anything. He might hear you." Then we have that final text at 11:17 that said, "I'm scared, babe." So what we have is about 16 minutes in between the first and the second text. Ask yourself, if Andy McCauley was in that room, don't you think he would have seen her texting? Don't you think he would have seen her on that phone? And despite that fact, despite the fact that he knows that every single night she is on a FaceTime call with Hayden Lacey, every night. Mr. James made a point of that I don't know how many times, up to 48 hours, 12 hours a night, all the time. Despite knowing that fact, he would choose a Tuesday night to go in and attempt to sexually assault and murder Riley Crossman. We also heard from and was texting back and forth with Riley on May 7th. Last text from back to Riley was at 12:40 a.m. Unfortunately, we're not sure the series of texts from to Riley when those occurred. We know that Riley was already on the FaceTime call with Hayden because he told us that. They were texting back and forth. He said all of those texts were within 5 to 10 minutes. And Mr. James tried to do a good job to correct her, ask her maybe she wasn't sure. But when I asked that question, he said all of those texts were within 5 to 10 minutes. Which means after 11:17, Riley Crossman was texting with. That's probability, and that is possible based upon the screenshot we saw. So if that's the case, where's Andy McCauley at that point in time? Because in his closing, Mr. James seemed to indicate that it was 1:54 a.m. 1:54 a.m. when Andy McCauley started to panic. That's when he started calling Don Morgan. So we've got Riley texting, and then we have a roughly 2-hour time frame. What occurs during that time? All we know is Andy McCauley went out to buy drugs. Maybe he wasn't honest about what kind of drugs he was buying. Maybe he didn't want to say he was buying drugs from Chantel's stepdad. His wife was a judge in this county. Maybe that's not something he wanted to tell the police officers. Addicts lie. Addicts lie to cops. Ladies and gentlemen, the evidence presented has not been sufficient for you to render a verdict of guilty beyond a reasonable doubt for counts 1, counts 2, or counts 3. You will have all of this evidence before you. When you go back to deliberate, you will have the lab reports. You will have the physical evidence. You will have the audio. Review it, scrutinize it. Earlier in my statement, I talked about emotion. And clearly, based on what you've seen in the last week, this is an emotional, tragic case. Asking you to disregard that it would be callous. But what I would ask is that when you go back into that jury room and you start your deliberations, you don't let that emotion override your obligation and your duty to carefully, thoughtfully, and impartially consider the evidence presented over the course of the last week. And after doing so, I would ask that you render a verdict of not guilty on all counts. Thank you.
So, Susan, the devil is in the details, and the defense attorney really did outline the different time frames in 16 minutes between her first and second, where, to me, I read between the lines as to say if this defendant was really going to do something to her, he would have done it then, knowing that she's texting. And then the 2-hour time frame when he was out buying drugs, doing things maybe he shouldn't have, but no evidence that he actually killed the victim in this case. What are your thoughts listening to that closing argument?
Well, the portion that I'm looking at my notes, the portion that I found the most unbelievable here was that addicts lied. I mean, of course, I found that believable, but this particular addict lied because he didn't want to tell the police who he got his drugs from. Really? In the grand scheme of things, that's what he's worried about. He's possibly murdered someone, and he's worried about ratting out someone whose wife is a elected official. I just find that weak, very weak. I think that he could have focused more on the DNA. The DNA evidence was really within, that's their best argument, and the motive, the lack of motive. I mean, of course, he does go over those things some. And I really liked we didn't show it just now, but I really liked what he said about the cat and a mouse being in a box, and then you close the lid and you open the lid and only the cat is there. You assume that the cat ate the mouse. But then if you do the same thing and there's a little hole in the box, then that's reasonable doubt. And then you're like, well, did the mouse get out or did the cat eat the mouse? That was a lot to follow. But he did it so much more eloquently in his closing statement. I thought it was a great way to break down reasonable doubt, because even hearing those jury instructions as an attorney, doubt that causes one to hesitate to act still is hard to understand. So I thought he did well with that, but bad facts doesn't make him a bad attorney.
And I do like that analogy as well with the cat and the mouse that you just described. I listened to it and thought that's actually a really good way to move forward and use as an example for the jury to understand that reasonable doubt concept. All right, Joseph, Susan, you're both going to stay with us, which I greatly appreciate.